Oh, good. This does appear to be working. Great, because I have a little bit of time free where I'm able to record this video update. Now, hopefully it does work because I haven't got that much time. And if it doesn't work this time, probably not going to re-record it. I've been experiencing some technical difficulties. Might be due to storage capacity, but there seems to be something else that's bothering it, particularly in recording my audio. So I'm hoping by the time I'm done on this occasion, you will actually be able to hear what I'm saying. Anyway, in regards to updates, I know it's 30 days into 2023, and this is my first update of the year. I don't think you guys actually expect them that regularly from myself because you understand that I'm busy in the real world, attempting to set up a very complex organization, the White Indigenous Rights Alliance. I'm doing an awful lot of the work for that myself, although I do have a fantastic team on board who are amazing and very talented. I obviously, with the scale of the company, have an awful lot to do. Then there are my cases, which is mostly what I'm going to be updating you about today. My case against my former university. As most of you are aware, I'm suing my former university and law school for discrimination underneath the Equality Act, victimization, harassment, discrimination of my philosophical and factual beliefs under the Granger versus Nicholson case law, and also not upholding my right to freedom of expression underneath the Education Act and the Human Rights Act of 1998. And so far, this has been going on now for a couple of years. It's been very long and very stressful. And we're still not at the trial phase yet. And this is mostly due to the actions of the defense submitting applications to strike out my claims, which have been unsuccessful. And this is what I would like to report on. So those of you who follow my channels have probably noticed that it's got a little bit quieter on there. I actually shut down my chats for the first week of this year because I had university assignments that I needed to complete. And also I needed to prepare for 2 court hearings, which took place on the 13th of June. So there was an oral reconsideration for permission to appeal that took place first, and then the permission to appeal or the appeal hearing for the other areas that I had asked to appeal from the judgments that had taken place on the 30th of June. So on the 30th of June, it was the strikeout application and hearing my application to amend my particulars of claim. My application to amend my particulars of claim was successful. The strikeout applications against my particulars of claim were mostly unsuccessful. There was only 4 paragraphs that were struck out pertaining to 2 different claims. Now, within the claims that I brought, there are multiple counts of such. So this pertained to discrimination in regards to a bursary scheme and also discrimination in regards to advertisements. The advertisements I decided not really to contest on the basis of my claims are already really complex, and now with some experience of how things are conducted within courts, over complexity takes attention away, particularly the judge's attention away from the key points and legal claims that you really, really do want to advance. I mean, the ones that are very much the strongest that you believe should certainly win if there aren't any errors in law. So I successfully managed to appeal the claim that was struck out pertaining to the discriminatory bursary schemes of the defendant. I didn't bother to really defend the advertisements because it'd be quite a complex argument to make, and it's going to take some time within a trial to make those arguments. And like I say, I don't want to make my case overly complex. And I think the direct discrimination claims, the harassment, victimization, discrimination of philosophical and factual beliefs, along with the obstruction of my right to freedom of expression, is quite sufficient anyway by itself. So the other aspect, the oral reconsideration for permission to appeal, was pertaining to aspects of my claims relating to psychological and emotional harm stemming from the discriminatory and victimization and harassment behavior by that I was subjected to by the defendant. Now, as a litigant in person, I'm self-representing. I'm doing all the work myself. I go into court, I submit all the paperwork, I have to do all the research, everything. I'm doing it all. So when you are a litigant in person, the self-representing party, it can actually be quite difficult to access services that might be necessary for certain aspects of your claim. Like, for example, independent medical examiners reports. Most of these people who could provide these, in fact, all of them that I try to inquire to, do not take instruction from litigants in person or unrepresented parties, even if you can clearly do so. So this puts you at a major disadvantage of not being able to bring forward these claims. And then there is also the fact that our legal system in many ways has become a money-making industry, and the vast majority of citizens in this country wouldn't be awarded legal aid because massive cuts have been taken from the legal aid pot. I mean, it's actually just been transferred over so that, you know, we can have all these human rights lawyers fight to keep rapists, murderers and terrorists in our country, illegal ones. You know, their human rights have to be upheld. But, you know, your basic access to your legal rights is non-existent. And this is what I was arguing in court, because the vast majority of citizens, not just myself, would struggle to pay for representation. They would struggle to pay the court costs, the court fees. And then they have to worry about, well, what if I were to lose? And they use this as an intimidation tactic. Many of you will have mortgages, dependents, and you think, well, there's a possibility I could lose my house. So even if you're wronged, you feel too intimidated to really seek legal recourse for that. And that obstructs your access to justice. Now, your access to justice is a common law constitutional right. It cannot be undermined by any law, any politician, any person, Marxist in authority. They can't undermine or obstruct your right to access to justice as one of the king's citizens. In fact, if it was going to be obstructed, let's say, by some form of legislation, some form of statute, it would have to clearly state within it that it has been given the right to undermine or to obstruct your right to access to justice, which things like the civil procedure rules don't have. Certain judges have obviously clearly not been given a notice by Parliament giving them unique right to obstruct our access to justice. So if a judge was to make a decision, or let's say a civil procedure rule in itself creates an obstruction to access to justice, then that is unlawful. I mean, this is still in force. I mean, I believe it goes to the Attorney General versus Times newspapers of 1974. I'll have to double check that. But it's Lord Diplock who clearly states the only way it can be ever undermined, I mean, by even the highest courts, is if they've been given clear statutory enactment to do so, which none of them have. So in my oral reconsideration to appeal, now that wasn't necessarily successful per se, although the judge does agree with me that there is a major problem within this country, that the vast majority of the king's citizens would not, in effect, be able to access their legal rights. They would not be able to access justice because it would be unaffordable for them. And this means if they can't access their legal rights, they don't really exist. So fundamentally, this is something that really does need to be challenged within our legal system. We need to make it so that the average citizen can independently access their legal rights or defend themselves from malicious prosecutions from our corrupt Marxist state. So anyway, people keep telling me that you can't do these things. Oh, you're definitely not going to win. Well, so far I've been quite successful. And that was as a novice litigant in person. When I first started this, I had very little knowledge of the legal system. I just knew that what I was doing was correct. I mean, I must be like the only nationalist that's ever looking forward to court. I posted that on my Telegram channel. In fact, I think it was like 2 days before I was due in for that those court hearings on the 13th of January of this month. I wrote, I think I'm the only nationalist that I'm aware of who's actually looking forward to going to court. I mean, that's understandable. Most people are not pursuing people, but being pursued. So that's completely understandable. But even the morning that I was due to go to court, I think I wrote Playtime Paris. And that's because I'm very confident that what I'm doing is right. And yes, I can succeed. And I don't care how many people out there tell me that it can't be done just because they can't do it. I'm going to show you that you can fight back and it can be successful, and that you should. We have a duty to. So anyway, that's the progress with the white indigenous, with the case against my former university, getting ahead of myself a little bit there. But with the White Indigenous Rights Alliance, so the progress has been coming along really well. I have been talent banking, and we've been making some big changes to our website, major integrations, mostly to comply with things like GDPR legislation and to ensure that the members only forums and the social media aspect part of it does work without slowing down the website too much. So that has been interesting. We've been looking into our other software applications and testing them, particularly for our animations and live worksheets that are going to help us to create the educational resources for our two education hubs, the Legal Education Hub and the Nest Education Hub, which is focused on children from ages like 5 to 17 in the 3 core subject areas of history, culture, and counter-critical race theory teachings. So I will actually be going into that in more detail in a separate video, because I want to do a recruitment video looking for people with specific skills, curriculum developers in those 3 subject areas, animators, voice actors, people who have a good knowledge and background with the white Indigenous history of Great Britain. But many of those people I've already spoken to. In regards to the other divisions and departments, they're coming along quite nicely. We're very compliant as a company, and I'm expecting, if all continues on schedule, I will be launching the organisation at the end of this year. I'm hoping in November. But I'll have more to update you on in a couple of weeks about the Our Futures division of the White Indigenous Rights Alliance. That's the one that has the Nest Education Hub, where I'm going to need the animators and the curriculum developers. But basically, that's where I am with the projects. I've been very busy with that and completing my work for university and dealing with quite a number of persecution events that have taken place. Let's call them that. Persecution events that were a little bit unexpected and have caused some challenges, but everything seems to be going quite well. Studies are going well, company creation is going well, litigation is going well, and my personal improvement projects are going very well, particularly in my fitness improvement, strength, speed, even my endurance has gone up, particularly with my cardio, so I'm most pleased about that. But anyway, I don't think you want to hear about my personal improvement projects or how they're going. You just want to hear about my activities that impact you guys. So I'll try and keep that out of it. But there you go. Recorded the update. Let's see if the audio actually plays when I try to post this shortly. Expect another update in around 2 to 3 weeks. This will be regarding the White Indigenous Rights Alliance and the Our Futures division. Until then, I'm probably going to be, again, quite busy, as I'm going to be preparing for the costs hearing and case management hearings, and also arranging visits. Anyway, until next time, I'll see you soon, guys.